Um, so welcome everybody. What we thought we'd do on the Thursday before a long weekend when probably a substantive topic might not be the best, we thought we'd go with going through a client file checklist. And this is something that's available now for anyone. If you go to the Estate Planner website under resources, this is a checklist, and it is a downloadable checklist. So you can download it and start using it for yourself, and basically edit it the way you want and that kind of thing. But what I thought we'd do is sort of run through it, and Ian, you can give your view on a bunch of the different steps, and we're going to open it up to lots of questions, hopefully, about different steps and those kinds of things. So Ian, before we start, any kind of comments?
Yeah, I just want to make the point, and I think the usefulness of this tool is that it's a file checklist, and it's not the planning checklist that you might be using in your own practices when you're taking the intake. eState has, I think, essentially eliminated the need for a checklist for the actual planning steps, especially with advisor alerts and so on. But this allows you from start to finish to efficiently move the file along, which is the most important client service part of the whole process. So I just wanted to sort of set the stage as to what this tool is really designed for.
Right, and it's, yeah, as you say, it's not a gift by gift sort of checklist, but so we broke it down into 8 sort of steps. The data collection, retainer, planning, drafting, client review, execution, storage, delivery, and then reporting and closing. And so maybe let's just spend a few minutes on the data collection, which, it's the worst part, in my view, of the job, and collecting the data. And yet it's the most, in a sense, the most important from a negligence point of view, probably, and from a client service point of view, and to give the proper advice, is getting this data that we need, that no one really wants to spend time giving us, right?
Yeah, and I think we all have our own shortcuts and tools that we use to ensure that we get all the right data. But it's also the documenting of the data requests and the actual receipt of the data that is a huge defense mechanism if you're facing any criticisms of your work product down the road.
So yeah, I think maybe what we'll do is focus a little bit on the the solicitor's negligence maybe side of things. If we maybe not negligence, but at least protecting ourselves. We've talked a lot, I think, in previous ones about gathering family information and that kind of stuff. So I don't want to, how important that is. Obviously, not missing a family member, not knowing that they're not actually a child, but they're a stepchild, those kinds of things. The idea, what do you think? And I've had this question posed. You send out a questionnaire, you never hear back, or you send out your initial sort of stuff and you never hear back. Do you think you're on the hook for that if the client dies and you haven't followed up? Do you see any concerns there?
I do, for sure. And I think it also ties to the nature and extent of your retainer arrangements as well. But I do think from that standpoint, it is scope of the retainer, and identifying that right from the outset is important in respect of the data collection, for sure.
Right. I mean, from my point of view, if I send a questionnaire to somebody who hasn't signed, I haven't signed, certainly they haven't signed a retainer or anything like that. I mean, I'm less concerned about that, to be honest with you, that they never get back and fill in their questionnaire and set a date for us to meet or anything like that. I think the risks there are low, to be honest with you. Assuming I haven't met with them, I haven't done anything except send them some questionnaire to fill out, which they never get back to me on.
Yeah, I don't, and I think you're supported by the case law that you haven't actually engaged a retainer there.
Right. What about previous wills and powers of attorney? How important, and from your experience with Law Pro situations, how important is that?
Well, sorry.
Like gathering the prior wills and powers of attorney.
Oh, I'm sorry.
Yeah, they can't sort of, "Oh, I don't know where my old one is." I hear that all the time. I don't even know where my old one is. In a perfect world, of course, we'd get them, but how important is that?
Well, I think it's a lot less important, depending on the circumstances. If there isn't going to be a substantial change or a red flags kind of instruction situation, um, it's the principled reason and the rationale for the change. It feeds that information flow. So you would like to get it if there is going to be a change in the circumstance. Of course, you won't know if there's going to be a change without the will or not. But it's it's funny you say that. Like most of the time, it's really not that important. It's just like anything in law. Some of the times it's really important, and it
Okay.
can be a threshold question when you're sitting there saying, well, you've excluded your daughter
Right.
and you never pressed to see the prior will. You never made any questions, and so I look at it more as an extra resource if there's some red flags instructions coming in, and I will make more of an effort to get the prior will if I have to when I'm in that situation. But if it's a relatively principled set of instructions that you're receiving, I personally, look, most people who say they don't have it, they don't have it, and they may not know where it is, and it may be a document that isn't easily obtained. And so I try not to put up too much resistance at that early stage.
I agree with that. I mean, I say, don't, yeah, if you got it, that's fine. I don't know where it's 25 years old. I'm not going to be as concerned about that, right?
Exactly.
So let's turn. So assuming we've collected the data, that was the first step. This whole idea of getting retained.
If it's a
Um,
document we're going to
sorry.
rely on.
Oh, sorry about that. The whole idea of getting some sort of establishing the retainer between you and the client. We've given some examples of that. eState generates retainers based on that. How important is a written retainer here? So often we don't, historically people didn't even get written retainers.
Yeah, and look, again, it's easy, and you get pontificating a little bit sometimes when you get thinking about how to run your practice perfect. A written retainer is almost never obtained until the last 10 years with a will instructions. It's now much more prevalent, but it comes back to the least amount of resistance for the client and the least amount of resistance for you. And because of eState, because it really is a simple creation of a document that's already pre-populated, I really encourage it now. And I think we've really, that was a big part of eState. We looked at resistance, and the questionnaire is one of those points of resistance that you can only have so much control. Clients are going to do what they're going to do. Retainer, you have control of that. And so if it's created in a way, any document doesn't have to be eStates, but if you've got a retainer arrangement that can be done in an efficient way, it is just always better to have it if you can. And that's why it's worth putting in the effort to create that point in time document for you to have it actually meaningfully considered and executed by the client in a streamlined way.
Let me just talk about deposits. And when we use the term retainer, I'm talking now about sort of financial retainers. I mean, I never, and nobody, I don't think, ever got deposits, or maybe that's exaggerating, but many people didn't get deposits when they were hired for wills. And so if you were like me, you got, retained, and you started doing your work, and you did your work, and then you sent out the drafts, and you didn't hear, and you didn't hear, and you didn't hear, and you had that cabinet full of drafts that have been sent. You were worried about the liability side, but then you weren't even getting paid, which to me seemed crazy. So I tried to, how I often do things is I try them out and see, am I getting resistance? Well, so I tried it, and I said, look, when you hire me, I need an X dollar, deposit. No one ever raised the least concern. They got, I got it like that. All of a sudden, this is fantastic. I've got money there. If I never hear back from them, if I send them the drafts and I never hear back, I'm going to get my money and get paid. And so it's, if you're not doing that, think about, just considering doing that, because it really has changed that concept of working. One of the first lawyers I ever worked with said to me, it's better to do nothing than work for nothing. And so this deposit idea is really helpful. Do you have any?
Yeah, and I do think, just to add to that is, and some good things that have come out of COVID. The process of payment of legal bills now by Visa over online and so on is so much more efficient. It used to be pulling a check out of someone, oh, I didn't bring my checks with me or whatever. All of that stuff's gone. So again, there is no meaningful resistance from clients from a process standpoint. It's not going to be a headache for them, and it actually incentivizes them to get it done, which is part of your job. You want to incentivize them to get this actually signed and done.
And one of the things that we put in our retainer is that, I'm entitled to bill you 3/4 of the fee if I've given a flat fee at the time when I deliver the drafts, because quite frankly, that's where most of the work has been completed. And so that's right in the retainer. And so you don't get into a fight, well, you weren't entitled to this money, blah, blah, blah. So the next section is planning. And obviously this is where we add value. So I think that a couple of things, I'm just going to sort of hit a few highlights, and then Ian, I'm going to talk to you about notes and things like that. But, somebody comes in, the first thing I check is to see the family dynamics. I check my advisor insights and see, okay, I have a blended family. I have foreign assets. I have a disabled child. I have an estranged child. I have US people. Those are the things I want to know sort of right at the top. And that's why one of the benefits of getting as much data as you can. But even if I don't have a lot of data, one of the first questions I say when I look at the family tree is I say, okay, tell me, is anybody here a US citizen, US resident, disabled, or estranged? You can cover that and most of the time it's yeah, no, or yeah, actually, blah, blah, blah. And then obviously that's going to frame some of your planning. Getting that on the table right at the beginning, I think is so crucial.
It's so true. And it's one of those questions for those of us who've from time to time bought a bit of life insurance, the agents have to ask certain questions, and you fly through those questions like they're, in 30 seconds, which should, which are typically no, oh yes, and no. Well, this is the same thing. Asking the right questions to identify where there's a rabbit hole of work to be done is the key. And that's you've identified it, because most of the time it's going to be no. Oh yes, I do have a US passport. Boom. Okay. Boom. Now we're into a whole new area of planning.
Right. Ownership, item 3 there. This is the other thing that I almost, start, not the first thing I say, but I just implore my clients to understand that ownership is so important in wills. Depending on the ownership, you can only give away what you own in your own name in a will. So when people start talking about this corporation and that corporation and the assets that are owned and the bank accounts, and making it clear to them that that isn't, you don't own those. The corporation owns them. You own the shares. That's what you can deal with in your will. Joint ownership. So those kinds of key really, and trying to get through to the client how important that is. Really important in my view as well. Let's just talk about trying to do this simply in an understandable way. For those who have ever heard me talk about this, I'm going to spend 1 minute on it, but I'm going to just focus actually on the concept that a client I think needs to think about, which is at the end of the day, there's 2 kinds of gifts: an absolute gift with no strings, and then a gift with the word but attached, and that's a trust. And I found this to be such a useful, because again, it's only 2 things they have to remember. Just so helpful to have clients buy into the process and sort of know what, empowering them to say, oh, I used but, we're going to provide for the kids. Oh, I know we're going to need a trust. And, it's great for the client, but it's also easy to defend when this comes up. Why did you give this absolutely to the spouse who then changed their will and gave it all to their new spouse? Or why did you put one kid's money in trust and not the other? So that's my breakdown of trying to make things simple is, only 2 choices when you make a gift of any kind of asset. Ian,
No, I think it's just it is a tool that I use, and I've stolen from you many times, because it is such a succinct way of putting forward the most fundamental concept in estate planning.
Let's just talk about note taking, and maybe how things have changed a little bit. First of all, tell us about Rodney and what he was told about note taking.
Well, he does the great couple of great videos that he did over the years. But the old theory is that why would I take a note if they know? That means they didn't know what they were doing.
Right.
That was some of the old school approaches to that. Now, my dad, of course, was always made fun of that, and he also made fun of people who didn't keep notes, and he also made fun of people who would make a 1 or 2 line note, and that would be it. Again, because like anything in life, seeing this from the litigation standpoint, it's always a mistake to predict the files that you think are going to go sideways and the ones that are not going to go sideways. So if you can keep a process that keeps you well above the standard of protection that you need in every single document, you're going to be far better off.
And yeah, I mean, so I was a horrible note taker. I found it very difficult to take notes while I was talking to clients and engaging with them. I found that so difficult. Your notes are going to be relevant if the will is changed, if you're challenged, if somebody has questions about what happened, if there's an argument about what were the instructions, those kinds of things. Capacity issues. I just found it very difficult. And I, to be honest with you, I don't think it was it was the way we did it, and we still do it, but I don't think it's the greatest way. I use Zoom and I record. And before that, I used to record my conversations, and not a lot of people did that. And I don't know if a lot of people are doing it now, but I find it so useful it does show warts and all. That's true. But our job, quite frankly, is not, we can only do what we can do. But to hear what a client really wants in their voice is incredibly powerful. And a judge, what are you thinking about a judge hearing, the client say, yeah, I haven't spoken to my kid in 24 years. And I know I don't want them to get anything.
Yeah, I've flipped right around. COVID's taught me a good lesson. Especially with Zoom, because it gives you the context of the discussions, and I don't have any hesitation now in recording. Clients like it. Gives me a chance to go back over and say, geez, I forget what we were going to do with that one thing or something like that. And it is a profound record that will be, for future judges, more or less expected in some level, because they're going to say during COVID, you couldn't see them face to face, and you could have you were on Zoom, you could have pressed record, you didn't. Why didn't you? That kind of stuff is going to come up. So I'm a big fan.
Yeah, look, does it have a downside? Of course it has a downside. If you're leading the client through all of their answers, that's not great. But that's why it does. Yes, it ups it requires us to do a better job. And, we can't just write down what your recollection of things. There's a pretty good record of what was going on. But, I think at the end of the day, when you're weighing all the pros and cons, I love the fact that the judge would hear what the client had to say. And to upset that and say, oh, but the lawyer was leading, I prefer that. So
I do find that we're going to have to face the transition, though, as we get back to more face-to-face meetings. And Brian Schnurr used to have a video camera in the old days on a tripod in his office, and just turn it on and off when he had a wills instructions clients come in. So we might be getting to the point where we literally just have the technology ready to go in our offices, because a lot of us are seeing our clients now face to face more and more for even instructions.
Yeah, and I use just a recorder. But so the next section is the drafting, and I want to just talk. Obviously, we're not going to go too deep into the drafting side of things, but I do want to talk about how we send drafts out, and the usefulness of some functions of Word. I just want you to look at number 10 there. And whenever I'm doing multiple wills, even when it's generating using software or whatever, there's a great feature in Word that allows you to compare two documents. And it's under review and it says compare, and you can take any two separate documents, have them compared, and you can show the differences. I try to do that on every multiple wills file, even if I think I've got it perfect, just to make sure there wasn't some little change I made manually after the fact, because I use software, but after the fact that wasn't picked up in the secondary will, and takes about less than a minute. And I can easily check, go through it. Yeah, I see this. This is a difference that I do need to change. Same for prior drafts, to show the client, here's the changes from this draft to that draft. So I'm constantly using the compare function in Word, and it's built in. And it's because those kinds of things, especially if you're making manual changes, if you're doing anything manually, you should certainly deal with that. Anything there, Ian, on the?
No,
on
I
the-
think I listen, that's a good technology point that isn't overly technical. It's a great tool.
Good. So then I always send drafts. Any thoughts on not sending drafts or sending drafts?
Well, I just think that I'm a big fan of sending drafts, especially now. We're usually exchanging electronically, but I just want to make sure I put on the cover of the email that these are drafts and need to be reviewed carefully in that kind of language before. There was some historic case law on sending drafts out that made people a little more nervous, but I think those times have come and gone with the advent of electronic exchange, and it's expected that you'd send a draft. It's the smart thing to do. Clients will pick up on maybe you've inputted something wrong or a name spelling or something like that. They may or may not pick up on it, but it's always worth having the client read through it and having the comfort of saying, yes, the client saw the draft in advance.
Yeah. And obviously, if there's a guide that can go with it, or some visual, that can summary or something that can give the client some context to it, because no one, including many lawyers, if they got a will, would know what it's saying. I often joke, I say to them, okay, when we're doing the will review, I say, okay, let me give you a summary of the will. And if it's, I pull up my little graphic summary or whatever, but I often can just explain it and say, look, everything's going to each other. And then if both of you are gone, it's going to the kids in trust to age 30. And if everybody's gone, it's going to your siblings. And I said, and it just took me 10 seconds to explain that, but it's going to take me 20 pages. It took me 20 pages to write it. So giving context to it is an important stage in my view. So the other thing, and I've spoken about this, is the idea of tracking any changes. And so, when you do that review with the client, I'll often do it on Zoom with the file, the draft on my screen, and sharing my screen, even if I've sent them the prior draft. And I can go through it that way, and they can follow along, and I have a recording of what we're doing and why we're doing it. And if there's anything that still is outstanding, those kinds of things. Very, very helpful to do it. That I find very helpful, and client doesn't have to, they may have a whole list of questions, but I often go through it first before, because they'll ask this question over here about the administrative powers, and then they'll ask about the executors and how much are they paid. And you just end up so I typically would take them through the draft first. And I've probably answered all of their questions by the time we get to the end. But then I say, okay, now let's go through your questions and make sure that we've answered them all.
Yeah, and that's why I think recording is such an important step at this tool at this step. And even if you don't record at the intake, this is when this is gold.
Yeah. Execution, there's obviously, we have right now strict compliance and making sure they're done properly, and those kinds of things, and the whole counterpart issue and virtual signing, which we're not going to go into too much of. Affidavits of execution, as a matter of practice, I always do them if I'm one of the witnesses or involved. Do you think that's part of our duty to do that, or what's your view on that?
Well, I think it's it's an ethical obligation. I don't know that it's our standard of care or that it's expected. I find great frustration chasing down affidavits of execution. Historically, people have not paid attention to this. That's why with software like eState, when it gets generated itself, it is huge help. But I just also want to say that, regardless of the Ontario amendments to the legislation that are coming up for substantial compliance, I do not see the courts, they are going to expect perfection. And only, as the cases have done all throughout Canada on this, where the legislation's changed, they're only going to bend the rules they're not going to bend the rules in every situation. So I like to just say the rules still continue to be specific and compliant. Compliance must be perfect.
Just there, when COVID came and we got this new idea of virtual signings, one of the things we suggested was in those cases where you were doing virtual signings, that we'd have an affidavit, 2 affidavits of execution, one from each witness. I think, again, I don't typically do that. I mean, it's available, obviously, you can have as many. I think as long as all of the information that is needed to prove that will, namely the virtual presence and the fact that members is a member of, or one of the witnesses is a member of the Law Society, I think you can certainly get away with just one. Again, we didn't, we were kind of flying a bit blind in the sense that it was brand new. And so the idea of having one, especially if they were in different locations, they're all in the same, if you've got the 2 witnesses in one place, I'm certainly comfortable with one affidavit of execution. We've talked a bunch about fees before. And so in our last moment, we've talked about reporting layers. Do you have anything to say? Maybe we'll just spend the last minute on fees because it is a big, I mean, that's why we're doing this. We're not doing it for fun, or most of us aren't. Anything that you would say, based in your Law Pro cases, Ian, I mean, and I can say a little bit about this, but how many of those cases end up where the lawyer charged $300 or $500 and now they're being sued and they're going to have to pay a deductible? And so do you have any comments on that in our closing remarks?
Sure. I mean, look, first of all, it's very rewarding work, as opposed to litigation can be rewarding, but boy, on the solicitor side, this work can be very rewarding. You really are adding value to people's lives. So I proudly make my fees known at the outset, and I proudly put a fair price on what my effort's going to be on this. So that's number one. Number two is that, yeah, I mean, I never forget every time I do a will. Right now, if you get a claim made against you and you have to file and you have to pay your deductible, it's about $17,500 for a lawyer to have that defended. So not that every will should cost $17,500, but that needs to be top of mind in terms of what risk you're prepared to take to do this document.
Yeah. And, I mean, we did a comparison, and, using software versus not using software, it's a longer process. And so if you are looking for efficiencies, and there's all kinds of software, but it's going to make it more efficient for you. And you do, I mean, when I sell those Law Pro cases and the person charged $250 and now they're being just raked over the coals, never mind the financial part of it. And I think, and just a last comment, and I call out to, if there are any members of the Ontario Bar Association here, I would encourage you to talk to the executive about coming out on behalf of the OBA and saying why lawyers are important in this business. Because every day there's another article about how you can do your own will. And in some cases, maybe that's possible. But if people don't speak out about there being a need for lawyers in this area, I'm afraid that many of us will not be involved in this area. So my little plug, if you're at all concerned about that, that's something to mention. Ian, any closing remarks?
I echo that. sincerely. So no, I think that you said it well. And I think this is another helpful tool. Again, the more we can make this, the process of generating these documents timely, accurate, and less resistance on the client side and on your side, the more we're going to enjoy the work and the more value we're going to add to clients.
Great. So thank you all. And we'll see you hopefully all next Thursday. I think we're talking about trust companies and appointing them as
Absolutely.
executors and how that might fit in, or maybe why we shouldn't, or those kinds of things. So thanks again for participating, and have a great weekend. We'll see you again next week. Thanks, Ian.
Thank you. Thanks so much.